Okay, we are recording this webinar, FYI, and I'm going to go over a few logistics and then we'll do introduction. So our logistics, well, here's the agenda. We'll do logistics, we'll do questions. We had a ton of questions. We had about 79 questions, which was great. So we've tried to put them into these categories here for people who are newer, who are not sure about our role, wondering about family law, domestic violence protection orders, housing, etc. And then we're super excited about launching a legal advocacy survey today or tomorrow. And then over here, I wanted to just make sure everyone knows that on our website, we have a legal advocacy project. And you can find all kinds of amazing resources on our legal advocacy project page. So logistics. If you need help with hearing this webinar and it's a little bit low, you can adjust that in the audio settings, which are here. And this shows you how to do it. And if you have any problems, you can contact our amazing coworker, Amanda. And her number is 206-389-2515, extension 204. You can raise a question, raise your hand over here. You can write in the Q&A. We really hope you'll do that. And you can also write in the chat. Oh, it's great to see people writing in the chat. Thank you. Okay, and I'm going to be monitoring. I'm going to do my best to monitor the Q&A and the chat as we go. And then there'll be magically an eval that has only 3 questions will pop up at the end. Okay, so welcome to Debbie, Marisol, and Kendra, who are our amazing presenters. Thank you very much. Debbie, would you like to introduce yourself?
Sure. Hi, I'm Debbie Brockman, and I'm currently the program manager for ASPEN Victim Advocacy in Yakima, but spent 20 plus years as the legal advocacy director at the WSCADV in Kitsap County.
27 years?
No, about 23 years there.
23 years. That's amazing. Thanks, Debbie. Thank you for joining us from Yakima.
Sure.
Hi, Marisol.
Hi. Can you hear me?
Yes.
Okay, perfect.
Do you want me to introduce you, or can you introduce yourself?
Okay, my name is Marisol Melendez, and I work at Catherine Place in Tacoma as a program director.
And you have legal advocacy experience. You've been a legal advocate at the Pierce County YWCA.
Yes, I have been at Y at Fort Lewis, and also for immigrant survivors and refugee survivors at Tacoma Community House.
Oh, thanks so much for being here. Kendra, hi.
Hi, good morning, everybody. My name is Kendra, and I work at the Washington State Coalition Against Domestic Violence with Judy. And I have been here for, I don't know, 7 years, I think, working mostly on housing. I do have a background in advocacy and a little tiny bit of like specifically legal advocacy, but most of my work has been on housing work.
Awesome.
Great. Welcome. Okay. So here we go. So I wanted to ask you how long you have been doing, how do you feel about doing legal advocacy, and how long you've been doing legal advocacy? And I'm going to launch our poll. Oops, that's the wrong one. Oh, let me try that again. Here we go. Okay, how long have you been doing legal advocacy, and how do you feel about doing it? Okay, so we've got quite a few brand new people and people who've been doing it for only a few months. Congratulations. Thank you for joining the team, so to speak. And then, we have 2 people who've been doing this for 10 or more years. Great. Awesome. And then in terms of confidence, hey, pretty good, but it varies. That's great. About 1 out of 5 of you feel pretty confident. 1 out of 5 of you feel pretty nervous. Nobody said they were completely disheartened, so that's great. Thank you. Okay, I'm going to end that poll. Always good to know how we're doing. Okay, well, let's launch into these questions about, for new legal advocates, since that's so many of you. What does a new legal advocate do? Some people said, I'm new to this. Do you have any advice for someone who's just getting started? What are some of the best ways to provide legal advocacy for a client who can't afford an attorney? So Debbie and Marisol, do you want to take it away?
Sure. What I would just say to all of you that are new to legal advocacy or fairly new to legal advocacy is that, first of all, welcome. It's great to have more legal advocates on board. And I just want to tell you that this is probably going to be one of the more rewarding and interesting and also often frustrating positions or jobs you'll ever have. And I also just want to let you know that you are just beginning what's going to be a never-ending process of learning about what it is to be a legal advocate. I still learn things all the time after 20 years. So just know that you're just getting started, but there are some great places to learn more about what it is to be a legal advocacy. And I would say that WSCADV is your best friend. The State Coalition is your best resource for learning what it is you need to know to be a legal advocate. One way is through, they do webinars and in-person trainings at times throughout the year. In addition to this type of call-in show, they provide workshops at the annual conference. And also a really great place to start is with the online classes that you can access through the WSCADV website. Some of the ones that I would recommend to everybody, if you haven't already done them, would be to do there's the legal options for domestic violence survivors, legal advocacy essentials, and protection orders in Washington, the basics. So those are 3 different online classes that are a great starting place. And then you're going to learn a lot of what you need to know just by experience, by being on the job and learning how things are done in your particular county, because everything, the way that things work can differ greatly by county. So you have to learn like sort of who the people are involved in your county, how hearings are held, things like that. And that's going to happen just over time. I would also really suggest that it's a good place is to get connected with your coordinated community response team in your county, which is going to be a multidisciplinary team made up of prosecutors, law enforcement, advocates, CPS, just a wide range of different community partners. And you're going to learn a lot in that group as well. Marisol, do you have anything else that you would suggest for new advocates?
Yes, I would say that first, the coalition is a great place to begin, like you said. Going to the courthouse and finding out what their specific process is in your area where you live, because every county is different. And I agree with Debbie that you will learn as you go. It's important to connect with other advocates in the area also. And also one thing that is important is getting some information on trauma and how that affects clients in making decisions and, helping them with that. So you're aware, it's more a self-awareness. And then also, I think Legal Voice has information also. And the forms, if you want to review them, they are at the Northwest Justice Project, Washington Law Help, that can help you with protection orders. And you can look at some summaries for divorce and just understanding the process, because it's pretty complex. And sometimes you have a lot of questions, and some people will have assistance that you can reach out and get attorneys for clients. And in some areas of the state, you can't. You have to, guide the person a little bit, the survivor a little bit on where to get the forms and how to do that. And also getting to know if they have court facilitators, getting that information and, meeting with them and seeing how that works. It would help you immensely. Also, I forgot to say also for all of you, it's important to get down or get information about immigration also through Northwest Immigrants' Rights Projects. They do have Know Your Rights, and get some of that information, because very likely you will come in contact with someone that is not from this country, and it could be documented or undocumented person. And they can help. They're great help.
Kendra, do you have anything to add?
Sure. Yeah, I think that a lot of times housing isn't something that folks think about when they think about legal advocacy. And what we know is that a lot of survivors are dealing with housing instability, and also sometimes dealing with some legal issues around housing. They're getting evicted. They're having challenges with landlords. And so my piece of advice really for folks is just to do some self-study and learn up on what are the housing rights available to survivors who are living both in like the private marketplace, which means like renting from landlords, property management companies, and then also learning the protections for survivors who are living in public funded housing. So that would be like Section 8, public housing, just so when you're having conversations with folks and they may mention that, housing, they're having some struggles with housing, that you can have some sort of base understanding of what's available to survivors, and potentially use that information to advocate on behalf of them when it comes to their housing. And then, I also know that a lot of times people are dealing with housing in the court system too. So getting connected with your tenants union, Housing Justice Project, and understanding what other resources are out there for folks who are facing eviction.
That's great. Thank you. Thank you all. So good news, legal advocates. We do have a slide on this in the webinar later on that will have visually show you many of those resources. And here's the thing about doing legal advocacy. There's a lot of mystique, right? There's a lot of mystique around, like somehow, you're gonna, one day you'll feel like you do know it all and everyone's gonna respect you and know that you are the legal advocate. But it's actually just like anything else with DV or sexual assault advocacy, where it's just a matter of like really knowing the system and the resources and what happens for people when things go wrong. And if you figure that out, then, more and more resources, every week, every month, then you'll know so much more than anyone else. And it's kind of like, what we found with in the welfare public assistance system is a lot of times domestic violence advocates know more than the DSH's caseworkers because they've just, read all of the rules, right? So that's this kind of similar to being a legal advocate, is really finding out like what happens when someone is in danger of being evicted or has been evicted. Because, the housing, a lot of times with legal advocacy, we think it's all about protection orders, but the regular daily kind of just living on the edge economically and having no resources, kind of legal issues like eviction, being in danger of losing your job, dealing with, just family court stuff if you can figure that stuff out, then you're going to be an amazing legal advocate and a great resource for your coworkers.
And I just wanted to add one thing. This is Debbie too, and that's that as you're doing this work, I'm really a strong proponent of building relationships and partnering with other agencies in the community, because we really cannot do this work in isolation. We have to have those partnerships and collaborations. But also there is the other side of that, is that you have to really remember what our values are as domestic violence advocates. And so as we partner with other agencies, you have to make sure that you're keeping confidentiality in mind, and that as we become really, you know, chummy and good friends with all the other people, that we still don't ever compromise what we know about confidentiality, and that we don't just talk openly. We keep to those principles. And also that as we become friends, like, you know, over the years, I've become good friends with different prosecutors and different people, but you still have to remember when you're in your role as the advocate that you can't let that friendship or that relationship silence you, and that you're still always acting on behalf of the survivor, and not being afraid that you might make somebody mad or that you might ruin that relationship or whatever. You still have to do what you know is best in your role as the advocate. And there's going to definitely be times that you're not going to agree. You're going to have to disagree with law enforcement, prosecutors, social workers, just about anybody at one time or another. And you're just going to have to be able to do that. And hopefully the relationships are strong enough that they can handle that, and that they'll respect you and your role as the legal advocate.
Thanks, Debbie, for talking about the confidentiality piece. That's actually something that we hear most from legal advocates about. What can be really challenging is having those, you know, positive collegial relationships with law enforcement, prosecutors, judges, defense attorneys, and still keeping confidentiality and not compromising our values and our focus on survivors rather than on systems. Because, you know, systems, it's kind of like, for those of you who are Star Trek fans, you know, what the Borg says, right? Resistance is futile, you will be assimilated. And so our job is to always resist and not be assimilated into these bureaucracies that can subsume people, you know, can suck us up. So there's a few questions on here that I wanted to just see if our panelists have any comments on. For someone who's a longtime advocate but new to legal advocacy, what are the most important things to address when meeting with a new legal client?
This is
Okay,
Marisol.
so, okay, go ahead, Marisol.
I was going to say that the first thing is just listen to what this person is telling you. This is critical. And then also try to connect with exactly what is the path they want to take, because your understanding of that is critical to assist this person. To me, safety is critical, and that's the first thing you will be evaluating in trying to make plans with the person, and understanding what is their level of safety. So the safety is, it will run the show and the client will too. So to me, those two things are critical. It's important for you to assess if the person wants a protection order, and also never forget that some people might be, we think as protection orders as like the first thing, but there needs to be a really thorough conversation with the client about safety, and the fact that sometimes protection orders make the person not be as safe as you want to. A lot of statistics show that people who have had a protection order, sometimes it makes the situation worse. And it's important to have a conversation with the client about how the respondent react and gauge that piece about the situation.
And this is Debbie, and I would just agree, safety is number one, but also being a good active listener as well. But there are some pieces of information that we as the legal advocate need to share with the survivor right away. And one of those is we need to explain to them you know, some of their rights and some of the policies. In particular, we should explain to them our confidentiality policy and give them a copy of it, ideally. So they need to know what the limitations are to our confidentiality. We need to explain to them about mandated reporting to both CPS or APS.
Right.
We need to talk to them about if they were to say that they were a danger to themselves or somebody else, that would be an exception to confidentiality. We explain to them that we will only share information other than those other exceptions. We would only share information with somebody if they give us a signed release of information that is very specific about what kind of information they would like us to share, with whom they want us to share that information, and it should be very time specific. It shouldn't just be an unlimited time, preferably like maybe whatever your agency policy is, but like 90 days. It should be time limited. Some other things that we should make sure that we let our clients know is we should be really clear about the fact that we are legal advocates, we're not attorneys, and we can't give them legal advice. We need to be able to share with them other resources where they can get legal advice. We need to explain to them that our services are voluntary, and we should tell them about what our policy is regarding their right to access the information that's in their client file. And then after we've explained to them some of these like basic rights that they have and our policies, then we can get really down to more of the listening and trying to see what kind of assistance they are looking for. But I do think it's really important to talk to them about confidentiality and mandated reporting, even before they sort of launch into telling us everything that's happening in their life, because they need to choose whether they want to, if there's information that they want to share with us or not, with that in mind.
Thanks. Okay, we're going to go on to the next one. Here are some questions that people had about our roles as legal advocates. You know, when do we know when to answer a question and when to just listen? How can we help people with paperwork, but not, you know, the really important legal paperwork, but avoid practice of law? Any thoughts on those things?
Lots of thoughts on those things.
Yeah.
So, okay, so let's see. So I would say that the burning question that every advocate is going to have eventually is like, what is the unlawful practice of law? What is the difference between legal advice and legal advocacy? And I'm going to say that the best training I ever had on understanding where this line is came from Jen Ammons from Northwest Justice Project, and she did a workshop at one of the WSCADV annual conferences. And then I also like followed up with her later, and she came and did a local training for all the advocates in our community. And I'm not volunteering Jen to do that in your community, but she does have a great presentation that she does, and she might be available to do that. So I think it's important for advocates to like really be aware that there is that line, and that and it's I would wish I could say that there's like just a definite place where you know, okay, this is I've gone too far, but I think you kind of have to keep in mind what is the practice of law, and so basically that means if you're an attorney, so you've been authorized to practice law in the state of Washington, and so if you are not that, then you cannot be practicing law, or you can't be pretending or representing yourself as an attorney. And the way that I can see that legal advocates can sometimes get into trouble with this is that they're doing their job as and advocating for the survivor, but sometimes they kind of cross over into having conversations with the attorney that might be interpreted as the advocate is negotiating on behalf of that survivor. And so they're kind of taking on the role of the attorney, and you have to really, really be careful of that. There's certain things that we can not do, and that is we can't tell people, give people advice as far as like, okay, you need to fill out this form and then provide them with that form. We can't fill out the legal forms for them. There's an exception to that, and that's with protective orders, and I'll talk about that in a second. But for the most part, we cannot tell them, okay, you need to get this form and you need to fill it out, and this is what you need to put in there. We can't tell them like what kind of relief they should ask for in their family law cases. We can't tell them what to put in their parenting plans, and we can't write that, you know, like I said before. But some of the things that we can do, and I guess that's probably even more important, we can help them in filling out all the paperwork for protective orders. And that's not just the domestic violence protection orders, but if it's a sexual assault protective order or an anti-harassment, a vulnerable adult, all the different types of protective orders. There is an exception to that unlawful practice of law that allows us to provide more assistance in those kind of matters. We can accompany petitioners to court on protection orders, but also on family law matters or criminal matters. We can go to court with them. There's often more leeway for what kind of assistance advocates can provide during protection order hearings, but you need to know what you can do in your county. In the counties I've worked in, the advocate has always been allowed to stand beside or sit beside the petitioner in protection order hearings and provide support for them, but not speak on their behalf. We can provide information of a general nature about the law and legal procedures. We can, let's see, we can also, when filling out protection orders or even family law forms, if they're working on them. So we can't tell them what to ask for or how to fill it out, but we can really help with like brainstorming ideas, asking a lot of questions to kind of get the survivor thinking about what it is they would like to ask for. So we can ask questions. Let's say somebody is working on a parenting plan. So you can't tell them, okay, you should ask for supervised visits and you should do it like A, B, and C. We can't tell them that, but we can ask them questions that are open-ended, like, well, what are your concerns about the safety of your children if they were to be with the other parent? We can ask them those kind of questions and get them thinking about, okay, you need to be able to articulate that. And we could ask them questions about things like, well, what would make you feel that your children would be safe in the care of the other parent? What do you need to see from the other parent before you would do that? So asking all those questions, that is okay. Telling them what kind of relief to ask for, that is not okay. We can explain things like the process about, like, you know, you need to go to the superior court, file your documents, things like that. You can give them that kind of procedural information. But also, you should be referring them to other resources where they can get information, such as your courthouse facilitator, possibly making a referral to CLEAR or CLEAR CV. If your county has a volunteer attorney program, just knowing what the different resources are for people who are representing themselves, so that we don't even get tempted to sort of cross that line into practicing law. Washington Law Help is a great resource because they can get not only get forms, but they can get self-help packets, which will give them the instructions on how to do things. And it's perfectly okay to point them to Washington Law Help, tell them that they have these packets, even, you know, go through those packets with them is okay. I think that's kind of all I have to say as far as like sort of really knowing what the line is between legal advocacy and legal advice.
That's terrific, thank you. And I wrote in the chat some resources from Battered Women's Justice Project, bwjp.org, on unauthorized practice of law and domestic violence, and also what ClearDV is, and we'll go over that in a few minutes. Thank you so much. Marisol, it sounded like you were about to say something?
Yes.
Okay.
I wanted to, one of the things that helped me quite a bit doing this work is always going back to providing the information. It's providing information and working with a client that you are a connector, but you are not the person that's gonna help them decide. The decision is solely them. I use sometimes an analogy saying, you know, I'm driving a car and you're sitting by me and we're going this way. I'm going to ask you, where do you want to go? And she said, right. And then I go, okay, well, if you take a right, these are the things that you, this is how you connect yourself going that way. So it's a connector for me. The other thing is, the filling out forms for clients, if you have a court facilitator, that is the best way. ClearDV also provides and talks to the client directly about, you know, pitfalls and things that you have not considered. It's always good to research before and get to know some of these resources. You're not there to make people's decisions. You're there to connect them with the systems and inform them on how they work. And that's about your job. You can provide support and explain, for example, one of the things that happens if they're filling out forms, like for example, for protection order, what does that mean? They're confused about the legal terminology. Even if they speak English, if they speak another language, from another country, that gets even muddier because they don't even understand sometimes our legal system. So it's important for us to, you know, it's a guide. We're not telling people what they need to do. That is critical. The other thing that you can do also is go to any other legal programs that you have around and make connection with the other advocates and what services do they have. Get yourself immersed in all the things that are available for clients and understand your role. Another role there that I wanted to also piggyback is that if you're a legal advocate, in many places, they will ask you to interpret for your client if you speak the language the client speaks. And that is a conflict of interest because what Debbie talked before, you know all these people in the courthouse, and they say, oh, but you speak the language, could you interpret? And that also is a problem because you are supporting this person and you might get into a situation that it's difficult for you.
How about with the attorney? How about if you're meeting with the client and Yvonne has the question, what if you're helping with translation with the attorney?
Well, I have done that.
Sorry.
So I have negotiated those terms a little bit because yes, I'm there and the client might not have an interpreter, but sometimes these attorneys are pro bono and they do have the resources. It's better if things are clean. However, I have been in situations in which I had to interpret for the attorney of the client. That's it. No one else, not the court, and definitely not a prosecutor or a police officer, anything. So it's better that you stay away from that completely.
Yeah, I agree with with that, and you will be asked if you you know, are bilingual. You will be asked to be an interpreter by many different people, and when I would say, to the best of your ability, avoid doing that. If especially like if it's a client who's receiving legal services or legal assistance through Northwest Justice Project, they have the ability to pay for interpreters. As domestic violence agencies, we should have the ability to have interpreters if we need them for ourselves. We should pay for interpreters. And the other thing about just in general, if you are accompanying a survivor to a meeting with their attorney, you be prepared that that attorney may not allow you into that meeting. They may ask that you wait out, and the reason for that is that it does compromise their attorney-client privilege if there is another person in the room. We also, as advocates, have privilege, so that's an issue that I'm not exactly sure how that would work. But I do know that a lot of attorneys prefer to not have somebody else in the room when they're meeting with their client. They might meet with their client, and then at the end maybe say, "Come on, you can come on in," and they might talk about some stuff that's definitely not that they're not concerned about privilege with. But just be aware of that, and as Marisol say, really avoid being the interpreter.
So we're gonna move on, but I want to just say there was another question about, well, what about with the court facilitator? And you know, this goes to kind of the overall role of the advocate, both advocating for individual survivors, but also advocating for all the rights of all survivors and navigating a bureaucracy that looks to us to do everything, and that, you know, our job is to figure out how to push back in ways that are productive, so that they're taking on their role. So going to some family law questions, and then we're going to dive into some protection order questions. So how can we support survivors on family law cases? You know, is it because, you know, these cases go on and on for years? What makes sense around going to attorney appointments, family court proceedings? And then this other question about how to legally support people around keeping their kids safe from the abuser, when the reality is that if they have joint custody and that kid is young, they're going to be seeing the abusive person for, you know, 10, 18 years.
That's a lot of questions, a lot of big questions.
Yeah, these are big ones.
Yeah. Well, as far as like some of these questions really depend on your individual agency and your capacity to provide all things to all people. We want to, but we know we can't, and so sometimes it is a question of having to like prioritize where you're going to put your resources. I think it's great if we can support survivors during family law cases by getting them connected first with resources. I think that's something that a valuable service that we're doing is we're doing safety planning throughout that process. So a family law case might be going on, and at the same time there might be a criminal case, there might be a protection order, there might be all these different things going on, and all of those things are impacting the survivor's safety. And so we want to be, you know, as I'm sure all of you know, we're not safety planning once and then saying, okay, checking that box and say we finished that, we did that. We're going to be safety planning as things change. If things start to maybe not be going very well for the batterer, and that might like escalate the survivor's danger level. So we're doing that all along the way. If you can go to court hearings, I think it's very, very helpful. That's a very challenging and emotionally difficult time for the survivor. There's also fear about having to be maybe at the same location at the same time. They have to be in the courtroom together. So just being there can sometimes just be a big help. And going to other appointments, I think it really does depend on what your agency has the capacity to provide. But I think that it's definitely something that survivors appreciate greatly. The question about how do we keep kids safe, that's such a challenging one. That's the big question. How do we keep kids safe? And I don't think that our system is is working very well in that way. You know, the survivor, like I said before, when you're helping survivors sort of brainstorm what their concerns are, and what kind of risks are there, and what kind of things might make the child be safer during the other parent's residential time. But that doesn't mean that the judge is going to approve those things. So you can ask for things like supervised visits, because I really fear for the safety of my child when during unsupervised visitation. But a judge may say, I don't see any, they may not go along with that. There might be a guardian ad litem that gets appointed, and that the guardian ad litem is going to do an investigation, and the guardian ad litem may not even recognize the domestic violence. Might be, you know, perpetrators can be very manipulative and very convincing, and they often do a great job of kind of pulling the wool over the eyes of guardian ad litems who haven't had a lot of training around issues of domestic violence. So you can try to do your best to prepare the survivor for when they meet with the guardian ad litem. Try to help them maybe pull together their documentation, police reports, medical records, school records, all that types of things for the guardian ad litem to take a look at, in hopes that the guardian ad litem will make recommendations that are geared towards the safety of children when there's domestic violence happening. But you can do all those things. You can do all those things, and a judge may still not go along with any of the things that you're asking for. I say then you've got to talk about it. It also depends on the age of the children, but you can talk to the parent about doing safety planning with the kids during visitation. But it's challenging and it's frustrating, because a lot of times the end result is parenting plan court orders that don't seem to be very protective of children.
Yes, I agree with that.
So this is where, you know, our work as legal advocates, where our work as domestic violence advocates is both about, you know, the immediate crisis, and then also prevention and changing public opinion in our communities. So I hope that for, you know, those of you who are legal advocates who are newer, that you're talking with the rest of your coworkers and with your director about, you know, how are we engaging in the community and really breaking the myth that what we're talking about is monster guys, you know, who are terrible people, rather than these are people who we all have relationships with in the community. And how do we, you know, begin more conversations that are one-on-one conversations about what does domestic violence really look like and what are the dynamics. So that's where your work as legal advocates is so important in changing the rest of the community.
I have a comment also.
Yes?
Can I continue?
Oh yeah, sorry.
Okay,
Marisol.
I didn't know. One of the things that I've noticed, sometimes because of the caseload and the amount of people that we have working with as legal advocates, it's very difficult to attend to every law hearing or anything that family law that you are. But it might be supportive or helpful to the survivor to connect with you afterwards and you know, see how from the emotional part to connect with you and see how things have progressed from her standpoint. I agree about the safety piece. You have to, every time you see that person that is going through that process, safety is really important, that you have to continuously evaluate how safe this person is. The joint custody, I see that more and more, and I do agree that it is a very difficult situation. All the things that Debbie talked about are helpful to clients, and you know, trying to support that person through that process. For example, with the guardian ad litems, try to you know, facilitate that process and be a receiving also information from the survivor, to create that connection, because this is a long-term proposition, and that connection with you is critical. And I know that we have a lot of clients that we have to work with, but I believe that even if you cannot go to a hearing, just being in the receiving end and supporting the person long-term, it just keep, how can I say, it helps them develop the confidence also, and their relationship with you. Okay.
Thanks, Marisol. So,
Judy, just to add to that, what you were saying about is that though we work with individual survivors, we also always have to keep the big picture, the system advocacy work is part of our job as well. And so ways that you can kind of do some of that on your local level is you can make yourself available, make it known to the guardian ad litems who have to have continuing education, just like everyone else, that you're available to come and do training for them. For attorneys, the Bar Association, letting the family law attorney know, letting them know that you're available to come and do trainings to them as well, because everybody's always got to have those training opportunities. For law enforcement, for everybody, just making sure that they know that that your agency is there to provide that type of continuing education, and that you're known, that your agency is known as an expert on domestic violence in your community. And then also just like, so that's one way to do that system change work, but other ways of doing that is through those relationships that you make over time. You're not going to have them instantly, but over time you're going to see them at different meetings. You're going to like have, you know, conversations, and it will get to a point where you know, I had a relationship with commissioners who had been there for years and years, and you know, it took a long time to build that relationship to the point where they would say to me, Debbie, tell me how things are going. What are some things that you're seeing and noticing? And actually, it was great to have them be open to not hearing like, okay, on this particular day on this case, you really screwed it up. You know, not that type of thing, but more like, I'm seeing this happening, I'm concerned about this. I'm concerned, like, here's a big one that would be, is like, I'm concerned that you're not ordering the surrender of firearms on any of these cases, or something like that. Making sure that you have educated yourself really well before you have those conversations. But if you can get the ear of people in those powerful positions, you can make change in your community.
That is definitely.
Yeah, it's really, I mean, that's the power of legal advocacy, right? We're not just there to serve people, we're there to carry out our vision in the community.
That's right.
Absolutely.
So one of the things I wanted to make sure everybody knows about is this incredible victory around child protective services and child welfare for domestic violence survivors. Have people heard of this case with a survivor named Amy, who's an Iraq War veteran? And she went to seek help, and child welfare took custody of her child. So, you know, this is an ongoing issue, you know, for more than a decade around, you know, systems blaming victims around not keeping their children safe rather than looking to the abusive person, the abusive parent. So this is, you know, breaking news. We're really excited about this case, and looking forward to what's going to happen next. DSHS and Child Welfare and WSCADV are starting conversations about this very thing. And, you know, applause to our colleagues over at Legal Voice. Some of you may remember them as Northwest Women's Law Center, and they changed their name to Legal Voice. Yay.
Yep.
Okay.
So Judy, before we go on to protection orders, I think this is a really good place to talk about what what kind of advocacy do we do within the child welfare system?
Mm-hmm.
What kind of legal advocacy do we provide to survivors who find themselves caught up in dependency actions, and I think some programs kind of take on the view that we don't belong in that arena, that the survivor has an attorney representing them, and I have to say that I totally disagree on that. I feel like there's so much work. It was probably some of the hardest work that I've ever done is advocacy within the child welfare system, both on behalf of individual parents and also to try to make some system change. And I know WSCADV has been involved in this for a long time, and which was great because I got a lot of support from them in doing that work. But what I would say is that, as Judy said before, a lot of times advocates do know more about the child welfare system and their responsibilities than the social workers themselves, because it's a huge system, takes a long time for training to trickle down to all of the social workers, and we've been getting this training for years. And so I would say you need to know what the social workers practice guide says to them that they're supposed to do around when there's domestic violence and also child abuse or neglect. We need to know to hold them accountable to actually being aware of it and following their own policies and guidelines. And so one of the things this is my tip, that whenever I was attending a family team decision meeting, known as FTDMs or any other kind of case staffings, I would bring that social workers practice guide with me, and make it very obvious, because I wanted them to know that I know it, and that I hope that they know it, what's in it. And then if necessary, refer to certain parts of it if it's not happening. If they're not making attempts to keep the children with the non-abusing parent, if they're not recognizing that that's what's in the best interest of the kids. I know obviously there are times when there are a lot of overlapping issues that it's not just the domestic violence. But I just really feel like we can do a lot to help parents caught up in that system by attending meetings, by going to court hearings, by making sure that we are holding people in that system accountable.
Thanks so much, Debbie, for saying that. I really, this again goes back to a lot of, it turns out, because there's so much turnover in the child welfare system, many of the, and I'm curious how many of you have encountered this, many of the child welfare workers do not know their own policies because they haven't gotten training on it, on the state policy on domestic violence and child welfare, and that, for example, that they cannot remove children based on the non-offending parent's victimization. They cannot do that. And so I've put in the link, if you read this practice guide, you're gonna know more than many of your child welfare workers, and you'll be able to, do just what Debbie said, is act as if you know and be a resource for them. So I've put in the chat a link to where to find the social workers practice guide, which was written by Margaret Hobart, who used to be at WSCADV, and Dr. Ann Ganley, who's a national expert. And then also, I'll put in there, at that same link, you can find posters and info cards that you can have in your lobby on what are the rights for DV survivors in that system. Okay, so we ready to do protection orders?
Ready.
Okay.
We got a couple of questions here. What do you do about safety when a judge denies the protection order? How can I assist clients who are fearful for their lives? How do you get a PO, a DVPO, when there's no evidence of physical abuse? Maybe it's all technology-based. When the survivor is actually homeless, so doesn't have a residence that they can put on the paperwork, or if they and the abusive person are in the same building, Or, you know, like a really common situation when you're dealing with a judge in a conservative area, conservative judge, conservative area of the state, and, you know, are there any tips about how do you write in the protection order? Or, you know, the survivors like heard, you know, on TV, like the thing to do is to get a protection order, but I already know that the judge isn't gonna sign this protection order because what happened to her wasn't as severe as what the judge is looking for. So any thoughts on those things? And of course, what about working with teens? What about the custody issues? A lot to cover. This is a whole webinar, but maybe you could pick one or two that you feel like ready to answer.
Well, I think protection orders you can help a person a lot. To help with the protection order, if you are in a rural area, you might have to assist with the process. They have to write their own declarations, and just trying to support the survivor in an organizational way, how to set out their information. That's a great help. I'd say many times, sometimes judges do deny domestic violence protection order, and you have to sit down with the client and assess safety and make sure that that person is connected. Maybe she can go ahead and, you know, it could be, what is their living situation? Where can she relocate? How would it affect the children? So it's a big conversation about that. The other thing is sometimes attorneys get involved, and sometimes you can request a reconsideration with the same evidence. Not you, but the attorney. So connecting the person with attorneys that can support and guide that too. Sometimes just helping persons organize the history of abuse. They might not have it all together, or they have gone through it, but putting it in a way that the court will be, how can I say, in a way that the court will read it and understand the fear for the person, for the situation that they're in. The technology, I've had persons that receive a lot of Facebook and stuff like that, and at that time we began, she began making copies of it or making pictures of it and keeping a diary until she had enough evidence that, you know, the evidence definitely showed the intent to harm. And I'd say, I think safety planning is critical, and especially through those orders that are not approved. Okay. Yes.
Yes, I really agree with that last thing, is that even before the hearing happens, talking about the what is going to happen if this order is not issued. That once that order is going to be gone, how is it going to further empower the perpetrator, and what kind of changes in safety planning need to happen. I also just want to say that with protection orders, a pretty long time ago, I think it was Lee Hofheimer at the coalition that created a pros and cons before doing a protection order. Because I think there is, even by law enforcement, by child welfare, by a lot of people, think that the protection order is the answer to everything and will provide that ultimate safety for the survivor. And we know that that's not necessarily true. So you can get that on the resource library on the WSCADV site, and it's just a series of questions that you can go over with the survivor and helping them to decide whether or not a protection order is the best thing to do. It asks questions like, you know, what do you think his reaction is going to be if you get this protection order? And sometimes what they say is, he'll probably kill me if I get a protection order. He's told me before, if I ever tried to get a protection order or have him restrained from his home or whatever, that he will kill me. And so if that's the case and they believe that, then we're gonna talk about that, and ultimately it's the survivor's decision, but it probably isn't going to be the best thing to do, is to move forward with the protection order. So I love that pros and cons form. Also, not letting anybody pressure or coerce the survivor into pursuing a protection order. And this can come from well-meaning people. It could be friends, it could be family members, it could be co-workers, it could be child welfare workers, kind of requiring them to get a protection order. And with child welfare, I think sometimes the thinking is that this will be proof that the non-offending parent is actually trying to protect the children. And so really educating them that that's not a good idea, and that actually sometimes protection orders can make things worse. Also, when
just to follow up on that, can CPS require somebody to get a protection order?
In their practice guides, it says no.
Yeah,
they should not require somebody to do that. But that doesn't mean in practice that they don't do that. And so that's an area where we can provide advocacy, directly to the worker by saying, letting them know, no, this is not a good idea. This is the reason why we've actually, the survivor has given this great thought and has made the assessment, because she knows her situation and she knows the better than any of us. And she feels that this is going to put her in more danger to get the order than to not have it, and to make it clear that that is not good practice to do that. Another thing about when the person is filling out their petition for the protection order and doing their statement that they have to write, we can help them with one, reviewing what the legal definition of domestic violence is, because for a lot of survivors, there are things that have been, when they think of the worst thing that's happened to them, it might not be the physical acts of domestic violence or the threats of domestic violence. It might have been some very ways that they were just really emotionally demeaning to them. So helping them to understand what it is, and also because we go to the protection order hearings in the community that we are working, we know what the judges in that area are looking for, what they need to hear, and we can help them to sort of put their thoughts together about and do a timeline of kind of working backwards with the different incidences, but making sure that they're including those incidences that included the physical violence or the threats of physical violence. And if they put in there some threats that, like you reading it, you're like, I don't know if the judge is going to know why that is a threat, because it doesn't really seem like a threat to me, but to the survivor, there's real meaning behind it. For example, if he said he was going to take me to a certain place, and I know that at that certain place is where he, previously physically assaulted me and put me in the hospital, or if there's a song or there's just something that has meaning between the survivor and the perpetrator that isn't going to be obvious to the court or to the judge, then ask the survivor to explain what it means to them. Why is it a threat to them? That can really be helpful. That whereas something that the judge reading on might take at face value not to be a threat, may now understand why it was. Also, you can just talk with the survivor about whether or not there's any kind of corroborating documentation that might be helpful. When at the protection order hearing, the judge is going to be listening to the survivor, and then be listening to the respondent, and having to make a decision in a really short amount of time. And so they're going to have to decide if more likely than not, they believe that what the petitioner is saying is true. So if she can have some backup corroborating documentation, that can be helpful. It's also important for the advocate to kind of know how the hearings work in your county. Like, for example, will the judge take testimony from other people? Will the judge allow you to submit documents at the hearing, or do they have to be submitted ahead of time? The rules of evidence for protection order hearings are supposed to be relaxed. It says that in the statute. So they aren't necessarily run the way that other like family law hearings where everything has to be submitted ahead of time and all of that has to happen. So just knowing how things work in your county so that you can prepare the survivor for what's going to happen at the hearing.
Thank you so much, Debbie. I'm looking for that pro and con document, and Meta is saying that it's somewhere in our saved file, so I will be looking for it. I want to also point out to people that we have, you know, if one of the things, again, so much of being a legal advocate is just knowing more than most people do about survivors and systems, and you can do that by diving into things like the domestic violence, Washington State Domestic Violence Fatality Review, and finding out, for example, something that we did many years ago was, you know, really realize that, you know, judges sometimes have this myth that everybody is saying that their abuser is going to kill them in their protection order documentation, but that's not actually the case. And so we, you know, some really great advocates here did some research on that, and we have, you know, research material to show that when people are saying that their abusive person is threatening to kill them, then that needs to be taken really seriously. Same thing around, you know, abusers saying that they're thinking about committing suicide. So I put in the chat the Domestic Violence Fatality Review research, and you can download one of those reports or look around in your library, and then you'll know more. You'll know more than many of the people in the court.
That's so true.
How about some of these custody issues?
I was going to say, at least in Pierce County, they refuse to listen to some of the issues pertaining to custody of the children. They would say something that the family law hearings are going to decide that. So they actually encourage people to file for a you know, a divorce or a legal separation. In some cases I have seen, which is very unusual, but sometimes some commissioners have decided that it seems that it's in their scope to assign a visitation. It's really problematic. I think every county is different, and you know, I'm sure that everybody will should at least do some staying and listening to the court hearings and be present and just listen to what's going on in your own county and figure that out. And I have seen also commissioners say that, you know, you need to file for a divorce like pretty quick, if, you know, so the children have, you know, the other parent has visitation. So this is very disturbing, but it happens. So my preparation, you know, telling the survivor that this could happen, preparing them ahead of time about the hearing, what they might expect, and is critical. Yeah, that's what I have to say about the custody. It's pretty dicey. It shouldn't happen, but it does happen.
And I think that's another, like, you really have to know what's happening in your court. And because it really varies by county, there should be the ability for the judge to make some visitation, to set up some kind of type of visitation, or to say no visitation at this time, but at least address visitation and to include children on protection orders. And those are challenges that I know that advocates around the state are facing, is that even though children are included in the petition, judges will sometimes remove them at the hearing, and not include them, protection for the children. Also, they might, like Marisol said, they may sometimes say, well, there's going to be no visitation until there is further order of the court in a family law matter or something like that. Or they might only make the provisions about the children be for a limited period of time. They're not, none of these things are things that they should be doing, but they are things that happen on a regular basis. So you have to be prepared and prepare the survivor that the judge is going to probably ask you about your recommendations as far as the other party's contact with the children. So be ready with what you'd like to recommend, but also that the judge may not. The judge may say, I'm not even going to address the issue of the kids at all. And so kind of knowing, what to expect so that we can prepare survivors is the best thing to do. But really, if somebody has a protection order, they cannot be required to go get a family law order to address the children. So judges should be addressing it within the full order for protection.
Hey folks, I just realized that the resources I've been sending have been going to the panelists rather than to everyone, so I'm just resending those now. Sorry about that. Boy, there's just so many rich things for us to touch on, and I can see we're getting plenty of meaty topics for future webinars. So given that it's 11:14 and we have until 11:30, I'm going to move us along and thank everyone for their flexibility, given that we can't get to every question. Okay, we're going to skip our break. So I'm hoping that we can touch on, one or two of these criminal legal issues and then go straight to housing. One of the questions is how to get firearms or guns removed. I want to let you all know that we have, this is a big topic that WSCADV has taken on for many years. And we actually have a lot on surrender of firearms that's happening, that we have these resources on our website, and then we are actively working on this issue around the state. So the person to connect with is our coworker, Jake Fawcett. His email address is jake@WSCADV.org, and his phone extension is extension 211, so that's 206-389-2515, extension 211, and he would love to talk with you about this, about getting firearms removed. About avoiding mandated reporting when we're working with teens and youth. Marisol and Debbie, anything you can say about that?
Well, I think
I would say, go ahead.
Was that, it is important that you have a process when you interview someone or you do an intake. All those confidentiality issues need to be addressed ahead of time to make sure that that person receives, understands what's going on and where your limitations lay. When there's things that are more critical or kind of that you think that they might be trouble, I would definitely try to connect that person with an attorney for getting information before they disclose anything. And I tell them, if you are concerned about something that you are worried about that might move this into another situation, I would encourage you to meet with such and such person. That also lets you know that you need to make these contacts ahead of time. Talking to people who have, complete confidentiality and will be able to give them a truthful evaluation of the situation and how much problems they could be. That's been my experience. Again, is that issue of not providing resources, but not, trying to help them protect their information. as much as they can so they can make a decision that is leveled. That's what that's how I have operated with younger people and women in general, or survivors.
So I would just add that it's important for you as a legal advocate to know kind of what your agency policy is regarding working with teens, what age teens can authorize to receive services from your agency. And then also I look to WSCADV on this topic as well, because I think it's really is confusing and unclear as to if the violence is happening between teens, is that a mandated reporting situation for you as a legal advocate? And what I have found is that is not a question that there is really a real firm yes or no answer on. So you're going to have to kind of use your best judgment, look at some of the resources that are on the WSCADV website that there's one particular that talks about mandated reporting for teen dating violence, and kind of what it seems that in talking with child welfare, with WSCADV and everything, is that probably in most situations it won't trigger a mandated reporting. But then it could be also how old are the dating, the teens that are dating, that type of thing. What is the level of violence? But I wish I could say that, give you like a definitive answer that yes, every time you're going to report this to child welfare. But I don't think that's correct. I don't think that we necessarily are in a mandated reporting situation in most cases where it is teen dating violence. So I think what we can do, though, is really think about what kind of resources are we going to provide to teens. You know, we're still going to be able to talk to them about safety planning, talk to them about what healthy relationships look like, talk to them about pros and cons of getting a protection order if that's something that they want. Be able also, if you have friends or family members coming to you and they're worried, and what kind of information can you provide to them about how to help their teen whom they think is in a violent situation, a violent relationship. So we're gonna do our best advocacy, but not operate under the assumption that that violence in teen dating relationships is necessarily going to be a mandated reporting situation.
That's so helpful, Debbie. Thank you. Okay, and we have Marissa Alexander's picture here. If you haven't heard of her, you can look up her case right after this. But one of the things that we know is that most of women who are in prison are sexual and domestic violence survivors, and sometimes specifically for defending themselves legally. So that's a new area that we're working on some more. Okay, Kendra, you're up. Housing. We've got some great questions about helping clients with housing and dealing with these onerous application fees and evictions, bad credit, owed back rent. What can you tell us?
First of all, I just want to say that I'm so glad that housing came up in these questions, because I think often people don't see housing as part of legal advocacy. So I just want to say yay. I'm super glad people are talking about this. And I think that something that's a little bit different about housing is that a lot of survivors are experiencing issues with housing, but they're not necessarily being driven directly to legal advocates. So these issues just sort of span all of the advocacy that all of you are doing. And I think it's great that, legal advocates are starting to really think about this. Housing is, as you know, a huge issue for survivors, both in terms of maintaining their housing and getting into housing. A lot of the questions are, how do you even get survivors into housing that have, criminal histories, evictions, debt. A lot of this has to do with, the abuse they experienced. Also, how do you even support survivors into getting into subsidized housing? The thread that I've heard throughout this whole chat is just the importance of listening to survivors. So when survivors are coming to you and they are talking about having housing needs, really getting to the root of what that looks like for them. Sometimes survivors want to stay in their own home, so it's, how do you support them in doing that? Sometimes folks want to move to a new home for safety reasons. Sometimes they are looking for temporary emergency shelter. So just asking those critical questions of like, what is your situation? What do you need? And then, figuring out how to support that. I know there was a big question around housing application fees and the expense that comes along with that. There was a piece of legislation that was attempted to be passed for many, many, many years around having people only need to apply for or only spend money for like one housing application, like a background check and screening process. And then once an individual had that one, document, that they could go to various places and provide and present that application without having to pay additional fees. That never passed. Unfortunately, there was just a lot of pushback from landlords and property management companies, and as you probably are not surprised to hear, also the companies that process these applications, because it's their business and they make money off it. So people can request that every single time a survivor applies for housing, that they have to provide that $35, $40, $45 screening fee, and that is totally legal and unfortunate. There was a little bit of a win in that legislation, in that a landlord can advertise that they will accept a standard screening fee or a screening tool, so that some landlords could say, yes, sure, come to this conversation with a screening document that you already have, and we'll accept that. But I don't think that that's a widely used practice. I think landlords and property management companies are still continuing to require that every individual pays every time they apply for housing. That is why it's like really important to either get to know your community and figure out who in your community has funds that can assist in this, because this can be a huge cost for survivors who are low income. So, a lot of housing homeless organizations have funds that can pay for this. And then we also have programs across the state who are DV programs, who are you all, who either have, some of you may have VOCA funds related to housing. Some of you may be part of the DV Housing First demonstration projects. You might have WSCADV funds for that, or you might have other funds from United Way or your local city jurisdiction. So you can really support survivors in this, like, the costs associated with housing application fees, just by understanding what you might have internally to offset those costs, or what is out in the community that can help support that. So that's one of the questions I wanted to address. In terms of advocating for folks who have been evicted or have rental history, again, getting really clear with survivors around what they're dealing with when they're going to into conversations with landlords. Sometimes survivors haven't even ever checked their own credit. They may not know that they have rental debt. So working with survivors on navigating and figuring out, what might prevent them, or what might a landlord have a question about when they're trying to get into housing. And then either going with that survivor to have that conversation with the landlord, going with a letter from a past landlord saying, hey, this survivor is, this individual is paying off the rental debt they owed, having an explanation around the eviction, just being able to be really clear with folks so that people aren't paying this money to do these application fees and having these like poor screenings come back up, and then having landlords or property management companies just totally deny them. Those conversations can go a really long way in terms of upfront telling the landlord or property management company, like, an eviction's going to come up, this was a situation, or this rental arrears are going to come up, this individual is, making an effort to pay it down, here's a letter from a past landlord. Just being really clear about all that can be really helpful in the advocacy you're doing with survivors. In terms of Section 8, if people have Section 8, that is awesome, because that means that their rent is going to be affordable. They're going to pay 1/3 of their income. If their income is 0, their rent will be 0. So I think one of the biggest things about the Section 8 process is that it's really complex, just like a lot of these other systems. So it's having an understanding of the points in which people need to respond. It is such a bummer when we hear of stories where people get Section 8 and they don't find housing in enough time, and so they actually lose that Section 8. And that is just like heartbreaking, because getting Section 8 is, in a sense, like winning the lottery. It's such a scarce resource. So understanding that process and having conversations with survivors around where they are in that process and providing them support to make sure that they can acquire housing. I know that there was also a question around if someone has an eviction, can they qualify for Section 8? The answer is yes. If someone has an eviction on their record, that doesn't preclude them or ban them from receiving any sort of Section 8 or public housing, unless they had been evicted from Section 8 or public housing in the past, or if their eviction was drug related. There's just so much related to housing. I mean, I could go on and on. I think each of these slides could be a webinar in and of themselves. But we do have a lot of great information on our website. I see that Judy pulled up one of our housing help pages. There's also the housing assistance guide, which I think this housing help page is buried within. And it gives a lot of links and resources to the protections for survivors, both in public and private housing. And then we just have a lot of information on our DV Housing First webpage around what housing advocacy looks like. And we are also always available to field specific questions or just have bigger questions with programs around how to integrate housing into the work that you're doing with survivors every day.
Yay, thank you, Kendra.
Yeah.
Really great stuff. So,
did I cover it all?
Yes, you did.
Okay.
Okay, in our remaining 1 or 2 minutes here, I want to point people to resources around immigration. And I can send out these slides so you can find this stuff later, including a lot of, great videos, for example, about how to help people with e-visas. There's, so much about employment rights for survivors, and we want to make sure everybody knows that WSCADV has been working really, really hard and had incredible victories. Yay! The past couple of years, especially this past year, and that's because of all of you, participating in our advocacy work with the legislature. So survivors of DV, sexual assault, and stalking have employment rights and employers are prohibited in Washington State from firing people because of their victimization or because they're seeking help and might miss some work time. So that's really important stuff to know. And we have this poster that you can print out. It's on our website. We really want to hear what's happening for you and for the legal advocacy landscape. So today or tomorrow, I'll be sending out our brand new survey. You'll be the first ones to see it, launching now on legal advocacy, and you could also win a prize. So that'll be coming out soon. We have a bunch of resources, and there's just, womenslaw.org is a great resource. They have a lot for each state and territory. Legal Voice, the CLEAR hotline at Northwest Justice Project, and the CLEAR DV connection for advocates to connect with folks at Northwest Justice Project. And by the way, can anyone say how does CLEAR work? How does the CLEAR DV line work?
Well, there's the two different ways of accessing CLEAR. One is by calling during their hours, which I believe are 9:15 to 12:15. Correct me if I'm wrong on that, but by calling the 888 number. They also do have advocates on the CLEAR line who speak Spanish. That's one way to access them. You also, I believe, can do an online application, and then you'll be contacted by CLEAR. there's also what was called Clear DV, but is now called Clear CV, so it's Clear for crime victims, and that is where advocates can do a referral directly to the Clear CV program. And so it's a good idea, if you're not already, to make sure that you get on that email list, so that whenever they send out like a newsletter, give updates on the program, as well as periodically they update the forms. You can do a Clear CV referral with an online form, or you can also print off the form, fill it out, and you can fax it in or email it in to the Clear CV. And then usually what happens after you've sent that referral in is that the survivor will get a phone call first from Betty, who works with the program, and she is going to do some screening with the survivor, and then she's going to set up a phone appointment that will happen between one of the Clear CV attorneys and the survivor. And so, then that will happen. Sometimes survivors don't have a way to be called, so you could always set it up that the Clear attorney will call to your office and do the survivor will come there and do the appointment. Even if they do have a phone, I think it's sometimes a good idea, and something that I did quite often, is to have the survivor come to your office when that appointment's going to happen. You can just be an extra set of ears and maybe take notes about what information that the attorney is telling the survivor, because it can be very overwhelming, and it also might be a language that they don't necessarily speak as well as you do. And so you can sort of take notes about what kind of steps that the attorney is telling the survivor over the phone. And then I think that could be really, really helpful.
These are such great tips. Thank you so much. Okay, so we're coming to the conclusion now. Thank you, everyone. Boy, a round of applause for Marisol, Debbie, and Kendra, and then to all of you as legal advocates, whether you identify as a legal advocate or as an advocate who's doing legal advocacy, which we all need to be doing. Thank you so much for your really important and stellar work. We want to hear how it's going. Keep in touch. Hope to see you at the conference. We're going to have a couple of workshops on that pertain to legal advocacy, including immigration issues that we're cooking up. And please complete this survey at the very end, which, God willing, I'll figure out how to launch. Okay, so thanks, everyone, and we will see you. We'll see you around, and we'll hope to see you in Spokane at the conference. Thank you, thank you, thank you.
Thank you.
Thank you.
Bye.
Bye.
Bye.